had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To prove the crime of culpable negligence as a lesser-included offense of count 3 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. 1. Derek Medina exposed Isabel Vieira to personal injury. 2. He did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. An issue in this case is whether the defendant acted in self-defense. It is the defense to the offenses with which Mr. Derek Medina is charged if the death of Jennifer Alfonso resulted from the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. The use of deadly force is justifiable only if the defendant reasonably believes that the force is necessary to prevent imminent death or great bodily harm to himself while resisting another's attempt to murder him, or any attempt to commit aggravated battery with a deadly weapon upon him, or any attempt to commit aggravated battery with a deadly weapon upon or in any dwelling or residence occupied by him. The crime of aggravated battery with a deadly weapon is defined as follows. 1. Jennifer Alfonso intentionally touched or struck Derek Medina against his will, or intentionally caused bodily harm to Derek Medina. 2. Jennifer Alfonso, in committing the battery, intentionally or knowingly caused great bodily harm to Derek Medina or used a deadly weapon. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or the imminent commission of aggravated battery with a deadly weapon against himself. Aggravated battery with a deadly weapon has previously been defined for you. However, the use of deadly force is not justifiable if you find Derek Medina intentionally provoked the use of force against himself, unless the force asserted toward the defendant was so great that he reasonably believed that he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger, other than using deadly force on Jennifer Alfonso. Or, in good faith, the defendant withdrew from physical contact with Jennifer Alfonso and clearly indicated to Jennifer Alfonso that he wanted to withdraw and stop the use of deadly force, but Jennifer Alfonso continued or resumed the use of force. In deciding whether the defendant was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The danger facing the defendant need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonable, cautious, and prudent person, under the same circumstances, would have believed that the danger could be avoided only through the use of that force. Based upon appearances, the defendant must have actually believed that the danger was real. If the defendant was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or to prevent the commission of aggravated battery with a deadly weapon. The definition for aggravated battery with a deadly weapon has already been defined for you. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporary or permanent, or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Residence means a dwelling in which a person resides, either temporarily or permanently, or is visiting as an invited guest. If you find that the defendant, who because of threats or prior difficulties with Jennifer Alfonso, had reasonable grounds to believe that he was in danger of death or great bodily harm at the hands of Jennifer Alfonso, then the defendant had the right to arm himself. However, the defendant cannot justify the use of deadly force if, after arming himself, he renewed his difficulties with Jennifer Alfonso when he could have avoided the difficulty. Although, as previously explained, if the defendant was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of the defendant and Jennifer Alfonso. If in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether the defendant was justified in the use of deadly force, you should find the defendant not guilty. However, if from the evidence you are convinced that the defendant was not justified in the use of deadly force, you should find him guilty if all the elements of the charge have been proven. If you find that Derek Medina committed first-degree murder or second-degree murder, and you also find a reasonable doubt that during the commission of the crime and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused the death of Jennifer Alfonso, you should find the defendant guilty of first-degree murder or second-degree murder with discharge of a firearm causing death. If you find that Derek Medina committed first-degree murder or second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of first-degree murder or second-degree murder with discharge of a firearm. If you find that Derek Medina committed first-degree murder or second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of first-degree murder or second-degree murder with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means the defendant carried a firearm on his person. If you find that Derek Medina committed first-degree murder, second-degree murder, or manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of first-degree murder with a firearm, second-degree murder with a firearm, or manslaughter with a firearm. A firearm has been defined for you previously in these instructions. If you find that Derek Medina committed first-degree murder, second-degree murder, or manslaughter, but you are not convinced beyond a reasonable doubt he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of first-degree murder, second-degree murder, or manslaughter. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. The evidence which has been admitted to show other crimes, wrongs, or acts allegedly committed by the defendant will be considered by you only as that evidence relates to proving the relative physical abilities and capacities of the defendant and the victim. However, the defendant cannot be convicted for a crime, wrong, or act that is not included in the indictment. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You have heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether, when the defendant made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statements was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits in evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to each crime charged. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary forms of verdict have been prepared for you. This is the verdict form for count 1. It reads, in the Circuit Court of the 11th Judicial Circuit in and for Miami-Dade County, Florida, that is our jurisdiction, the State of Florida versus Derek Vernon Medina, we, the jury, finds as follows as to count 1 of the indictment charging first-degree murder. If after your deliberation you find that the State of Florida has proven the charge of first-degree murder beyond a reasonable doubt, you will mark next to line number 1. If you do not find that the State of Florida has proven that charge beyond a reasonable doubt, then you will move down to line number 2, which reads, the defendant is guilty of second-degree murder, a lesser included offense. If you find that the State of Florida has not proven that charge beyond a reasonable doubt, then you will move down to line 3, which reads, the defendant is guilty of manslaughter, a lesser included offense. If the State of Florida, as to count 1 of the indictment, has not proven a charge to you beyond a reasonable doubt, then of course you will mark next to line number 4, which reads, the defendant is not guilty. Now, if you have made a decision that the State of Florida has proven counts 1, 2, or 3. There are elections that you must make. On lines 1 and 2, you will need to make the following decisions. Whether the defendant carried, displayed, used, threatened to use, or attempted to use a firearm or not, you will mark the appropriate line. Then you will move down to B, which reads the defendant actually possessed a firearm, or the defendant did not actually possess a firearm. You will mark the one that you believe applies. Then you will move down to C, which reads the defendant discharged a firearm, or the defendant did not discharge a firearm. You will mark the one you believe applies. And D, the defendant discharged a firearm causing death, or the defendant did not discharge a firearm causing death. You will mark the one that applies. And those elections are the same for both lines 1 and 2. If you make a determination that the state of Florida has the highest offense proven by the state of Florida is manslaughter on number 3, you will need to make a determination only if the defendant carried. If you mark in line number 3, you will then have to go down to the next 2 lines and mark the one that applies. And those 2 lines read the defendant carried, displayed, used, threatened to use, or attempted to use a firearm, or the defendant did not carry, display, use, threaten to use, or attempt to use a firearm. You will mark the one that applies. When the jury has reached a unanimous verdict as to count 1, the foreperson will sign and date the verdict form. Moving next to verdict count 2. It reads, we, the jury, finds as follows as to count 2 of the indictment, shooting or throwing a deadly missile. Line number 1 reads, the defendant is guilty as charged in the indictment. If you feel that the state of Florida, after deliberations, has proven that charge beyond a reasonable doubt, you will mark line number 1. If you find that the state of Florida has failed to prove this charge beyond a reasonable doubt, then of course you will mark line number 2, which reads the defendant is not guilty. The foreperson will sign and date the verdict form and return it to the courtroom. Lastly, verdict form on count 3. It reads, we, the jury, finds as follows as to count 3 of the indictment, charging child neglect with no great bodily harm. Line 1 reads, the defendant is guilty of child neglect with no great bodily harm. If you find that that is the highest offense which the state of Florida has proven beyond a reasonable doubt, you will mark next to line number 1. If you find that the state of Florida has not proven that charge beyond a reasonable doubt, you will move down to line number 2 for your consideration, which reads the defendant is guilty of culpable negligence, a lesser included offense. If you find that that is the highest offense for which the state of Florida has proven beyond a reasonable doubt, you will mark line number 2. If you find that the state of Florida has not proven a charge beyond a reasonable doubt, then of course you will mark next to line number 3, which reads the defendant is not guilty. Again, the foreperson will sign and date the jury form upon the conclusion of your deliberations. Ladies and gentlemen, in just a few moments you will be taken to the jury room by my bailiff, Jose. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you all return. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about the case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, Facebook, or any other means. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff during your deliberations. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to Jose the bailiff. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have any questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Many of these exhibits will be sent into the jury room with you when you begin to deliberate. However, if you wish to view the firearm, knife, projectiles, casings, or videos, please request so in writing. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. As I said, ladies and gentlemen, in just a moment, Jose will take you into the jury room. We ask that you leave all electronic devices behind. Again, there will be pads and paper. You may take your notes with you into the jury room. In addition, there will be pads, paper, and pens. If you need to communicate with us for any reason, please just knock on the door. Jose will take the communication to make sure the foreperson signs and dates it. If your voting has begun, please do not include what your voting is, 6-6, 7-4. It's none of our business, okay? The votes and decisions of the jury shall remain their private affair as long as they wish it. I will also tell you that when you get the jury instructions, that you will see the initials IV in the instruction related to the neglect charge. Because this is a legal document, IV are the initials for Isabel Vieira. That is who that is, denotes, and because it is a legal document that will go into the court file, because of privacy interests of the minor, it is denoted in the jury instructions as IV, so that there will be no questions. Dinner has been ordered for you. What we will ask is we will ask that you begin your deliberations in a moment. Jose will bring in the evidence that is permissible to go into the jury room. I found one typo in my jury instructions, so I need to make that alteration, and then it will be. Then he will knock on the door and provide that to you as well. Mr. V asked us a question when you were impaneled. Are we all the jurors, or are some of us alternates? Ladies and gentlemen, we did have 3 alternates in this case. They are as important as any other juror in this case, because if one of you who are seated and that will be going back into the jury room were unable to continue with this process, as we did take so long, they would have been filling in. So today, jurors, you will be saying goodbye and thank you to Larissa Sanchez, Robert Clower, as well as Tiffany Cisneros. The 3 of you will not be going back into the jury room, but for those of you who will be going into the jury room, you may begin your deliberations now. All rise for the jury.
Please rise.
Jose, if you would escort them across the way, I'll be with them in a moment. You may all be seated. State defense, did I read the jury instructions as agreed, State?
Yes.
Defense?
Other than the typo.
I did find the typo, so I will go make that change. Otherwise, do we have an agreement as to the evidence that will be going into the jury?
Yes, Judge.
Yes, Judge. Those are not in evidence? Do you agree to that defense? That the DVDs actually aren't going into the jury room?
There's nothing for them to be able to view. Yeah, they can't view the DVDs.
Okay, so please, everybody, remain here because I want to make the change and make sure everybody's in agreement with the one change to the instructions. So I will be right back. At ease, everybody. Thank you for your patience.
If they want to view the environment, then they have that.
All the pictures are on there?
Yes, ma'am. There's nothing in there, right?
Okay, so let's go back on the record with the State Defense, Mr. Medina present. I've shown everybody the corrected version of the jury instruction, and just so it's clear from the record, and let's get to the correct page. It was in the instruction for 7.4, murder, second degree, in line E. I've changed the second Derek Medina to Jennifer Alfonso. Is the state satisfied with the alteration? Defense?
Yep.
Okay, so have we all agreed to the evidence that's going back? State? Defense?
Yes, Judge, obviously the weapons, the firearms, the CDs they're gonna have to ask to see them, and then.
Correct. They will
Correct.
do so in writing?
Yep.
Okay, so let me do this, and
Jose, make sure that everybody I know.
yes, everybody's there. Somebody left their pad out there, so, oh, I believe that's Mr. Clowers. That's Mr. Clowers' pad. Okay, so, let me, Ben Esther, may I borrow you to take this in, because Jose is getting transportation for the ordinance. They have to walk. And what evidence is on that? Okay. Okay, everybody quiet in the courtroom, please. Okay, so before we recess, are there any issues? Oh, sorry, thanks, Mary. She's talented. Before we recess, any issues from the state, from the defense? Okay, let me say this. Let me say a few things. Don't go too far because it's late at night and I want questions and issues addressed very quickly. Mr. Medina and everybody in the courtroom, I tell this in every trial. If we are told, if we get the knock on the door and we're told it's a verdict, it is courtroom policy that liaison must be called, which means that there will be a bigger presence of police in this courtroom. No one will know what the verdict is until it is handed to me and I get to read it. It is just policy because of security issues. So don't think it means anything one way or the other. I am also going to let you all know now that I am going to, when we are told it's a verdict, I will be making a statement. So it might as well sink in now that no matter whether the verdict is for you or against you, I am going to order that there be no reaction in this courtroom. These jurors have worked very hard for a month. We need to respect the hard work that they've been doing. This can't be an easy decision for those jurors. So with that being said, we will be in recess until there's a knock on the door. Okay? So, Jose, you want to take the food?